Yes.
Apart appeal in the matter of Scottish Power Limited and others in HMRC.
Morning, Steve.
Good morning. Good morning. Can I just sketch out what I was proposing to say this morning, which is hopefully not going to take too long. First of all, I was going to complete what I had just about started, which was to take you through the documents, starting with the letter at tab 20 and then moving back to show you the process and explain what the various documents in the bundle are. And then I was going to look at the findings of fact of the First-tier Tribunal, particularly in reference to three topics. One is the question of in lieu of penalty. The second is the wholly and exclusively findings. And the third is inevitability. And then I was going to wrap up with some brief comments on my learned friend's 8 features you remember he set out yesterday, in the light of all of that. And then Mr. Chaco was going to deal, hopefully briefly, with the issue of compensation, with particular focus on the 500,000, if you remember, that the First-tier Tribunal decided was deductible because it was compensation, and the Upper Tribunal said was not. So he's going to deal with that issue at the end.
Mr. Ewart, just one sort of general question,
Yes.
which you may or may not be able to help us with further, which is really the whole concept of a payment in lieu of something else having the character of the something else. I know it's not accepted on the other side that these are in lieu of penalties, but just if they were, which is your case, why does it necessarily follow that they should have the same character?
Well, it's not so much that they have the same character, but they would be serving the same function, and therefore the same policy would apply to them. I think that has to be our case, because that is the basis of Lord Hoffman's decision and the House of Lords' decision in McKnight.
Yeah.
So
You haven't drawn our attention to any case law that supports that proposition. And when I thought about it a bit, yes, you can think of case law where income, or something is treated as income of the same character as something it replaces. There's compensation cases. I think there's cases in an employment context, for example. But I haven't been able to think of authority on the expenditure rather than income side.
Following on from remember, the reason this arises is because we're following on from McKnight. So from McKnight.
Yes,
so
indeed. But you need to demonstrate effectively that sort of principle applies. And I was trying to understand whether there's any other case law that might help us.
Well, the proposition that I'm putting forward is that if there is the same policy imperatives in relation to this as there would be with the penalty, then the result ought to be the same, applying what the House of Lords said. I mean, that's the proposition. Yeah. And I would have thought that if that is the case, if the same policy arises, then the answer ought to be the same. I don't think you would need authority for that proposition. The question is, in this case, does the same policy apply? Is there any difference if they agree to pay the same amount that they would pay by way of penalty, by way of to someone else, by way of to charity or to customers or whatever? That's the issue. So I'm not surprised that there wouldn't have been any authority on that question.
Okay.
I wasn't. That's my answer. That's what I
Thank you.
Say. Right. I've been I've been on tab 20 in this bundle. most of my submissions, I think.
We'll try and restrain ourselves.
No, don't worry. No, I'm perfectly happy to answer the questions, but I just maybe we can go on to a further document. So I wasn't going to say any more about it. You've read tab 20. You've seen what the letter is. What I was going to do was then to take you back in the
sorry. Don't not take us to the relevant bits or emphasise the relevant bits in the letter, because it's an important. The exchange is, I think, an important background. So I don't want you to skim over the background to the document. So don't feel inhibited. You've got time.
Well, looking at the document itself, I think we've gone to page 204 at the bottom, where it's stating the settlement committee, that is within Ofgem, has agreed the penalty figure before discounts, and then we have the discounts, and they're noting that in the early settlement window, which one imagines was what was anticipated at this point would actually happen, because there has been negotiation before that, a discussion about it.
And the deadline for the early settlement window is the date of the agreement.
Yes.
I see.
Yeah. So it was being assumed, I think, at that point.
Well, yes, but they did in fact enter into the agreement on the 25th of April, as I understand it.
Sorry, yes, that's when they actually did it.
Yes.
Yeah. And then there is the paragraph below, second paragraph below the table, where they're expressing the view that it should be made as far as practical in the form set there. And then under that, there's the next steps. What Scottish Power would have to do if they wish to settle the investigation.
I mean, just starting to understand this. It's often said that the purpose of a penalty or a fine or something is both punishment and deterrence. And that is a particular hallmark of a penalty, a fine, statutorily imposed payment required to be made to the state.
Yes.
You would expect a regulator, presumably, to have regard to the desirability of deterrence and punishment as a feature of a penalty.
Yes.
Don't you lose those if you say, well, okay, you don't have to pay a fine which carries the substantial fine, and in fact you can do some other things by making payments not to the consolidated fund, not under the label penalty, just in terms of improving the lot of customers. And what's the thought process? I mean, you're not here for the regulator, and it's perhaps unfortunate we don't have the regulator here to explain itself, but we have what we have. What's the thought process behind saying, well, we'll just ditch deterrence and punishment?
Well, they're not ditching it, and later on in the documents, when we get to following documents, you'll see that they specifically state that it serves these purposes, which are punishment in the sense of, well, the way they describe it is marking the seriousness of the breach.
What, a £1 fine?
No, the whole amount that's being paid, and deterrence. Those are expressed to be the purpose of it. And why it is, one would assume, is because they still have to pay £18 million, which they wouldn't otherwise have paid. This is not something that they would otherwise have done, so they're still having to pay £18 million out of their coffers, which they wouldn't have paid, and there was before it. But I think Mr. Chacker's going to look at this. There was negotiation as to how much the regulator would accept that they have to pay.
But if it's thought that it's appropriate to compensate customers, and I appreciate that's a loaded word, but at least make payments to customers that do in some way reflect what customers have suffered, why don't you penalise the regulated entity on top to act as a deterrent? I mean, making good their relationships with customers is one thing,
but it is on top, because you'll see, I think Mr. Chaka's probably going to deal with this more than I will, but that these payments, when they are made to customers, leave the customers still with their rights to compensation that they had before. So these are on top of the customers obtaining whatever compensation they may be actually entitled to because of any losses they have suffered.
What's the rationale for that?
The rationale for that is that, well, the rationale for the whole thing, I believe, I'm not, as you say, representing the regulator, but I believe is they want the company to pay a sum that marks the seriousness and deters it and other companies from not complying with the regulations or not taking steps to comply with the regulations. So they want that money to be paid by the company. But I think that what the regulator thought was it's better all round, and it promotes maybe the purpose of the regulator in relation to customers. If the money is not just disappear into the consolidated fund, but actually goes to something related to provision of power. I think broadly that's the thinking, and so rather than saying we just have to pay it to the consolidated fund, they are saying you still have to pay 18 million, which you wouldn't otherwise have paid. Thanks. But you have to pay it. But you can pay it to, say, a charity which is in the field of this, or to all these customers, just giving them another £70 on top of what other entitlements that they might have. So they're not being discharged of their otherwise liabilities that they would otherwise have to customers. This is the amount on top of that they're having to pay. It's like being ordered to give a discount on the bills, essentially, of £70, or agreeing to as part. But the alternative is that they still pay the 18 million, but it goes into the consolidated fund. That's the alternative that they are. Yeah, sorry, I'm told that paragraph 134, that, I mean, this kind of thing was, I think, gone into in the First-tier Tribunal. There was evidence. And as a result of the evidence, you can see paragraph 134. We think it clear that Gemma intended the obligations to make the redress payments to be punishments. And they state
punishments or penalties. They've chosen the word deliberately, presumably.
Yes, it's not a penalty in the technical sense, but punishment. Because punishment can come up.
We've just probably got rather close to the real issue in this case, is does it have to be a penalty in the technical sense? And
we would say,
if it looks like a penalty.
That would be nonsense if it all turned on whether they chose a penalty rather than...
It just might require the regulator to make a hard call.
Or as my lady suggested, they might have to say that if you're going to take the option of paying, then you have to gross it up. You have to pay more than the penalty. Which would be a rather odd sort of situation. Because they're both intended. This is from the point of view of the regulator. I accept it's not from the subjective point of view of the company. They might look at it completely differently.
Were there findings made about the point you just made, that the amounts paid to customers did not in any way discharge any liability?
Yes, I was going to come to that, but when you look at the sections which explain in the judgment, which explain the various things, they do make these points, I think, in the FTT decision. The 4 investigations, and it begins at paragraph 36, which is under the heading, I'm afraid, which is on, in my copy of the page before, 4 investigations on the payments made on settlement. I think that is.
I'm sorry, I was reading the whole of that passage. Can you give me the reference you just...
Sorry, it's begins on paragraph 36.
36.
36 of the FTT decision, under a heading that is on the previous page, I think. And they deal with each of them in turn. And I think these points are made. I was going to show you, in fact, the letter, but paragraph 41 of the decision recites that the letter said the payments were not being made because we think you have been directly affected by these issues, but because we want to make payments to you as part of our apology. That's the...
So we now have payments as penalties, we have payments as consumer redress, and we now have a payment by way of an apology. Where does that fit in the statutory framework?
From the point of view of the company, I suppose it's an apology. From the point of view of the regulator, it's
why is it apologising to people who haven't suffered?
Well, it's just apologising, I think, generally, for doing wrong, perhaps. It's a bit of a fudge, this, but I mean, the idea was to ensure... the idea, I think, from the company's point of view, was that they didn't get such bad publicity from having to make the 18 million payment in that particular case than they would have if it was simply a penalty that went to... That's from their point of view.
So if a company voluntarily decided to get some good publicity by making a public apology for something that had gone wrong, would that be deductible?
And making payments.
Yeah.
If it was completely voluntary and they decided to do it for the purposes of, to prove their image, I would have thought it would be, yes, for the purposes of their trade. They do it voluntarily, yeah. I think that my learned friend's point seems to be all of this could have been done voluntarily and it would have been deductible. And I don't have any issue with that in another world where there was no regulator, let's say. They could have done all these things, theoretically, voluntarily. And they could have justified them as being...
And I think you also, I think, accepted yesterday that if the regulator had come and said, well, we're thinking of requiring you to make a consumer redress order, and the regulated entity said, well, actually, we'll make some voluntary payments instead that might satisfy you, that would be deductible.
We'll compensate them. Well, if it was going to be if the regulator said, we think you ought to compensate these people because they have suffered loss as a result of what you've done or not done, and the company said, okay, well, we'll compensate them for the loss they've done, then that would be potentially deductible. It's a different...
Does it have to be that narrowed? I mean, what if the regulator said, well, we'd be minded to make a consumer redress order, which I think has the possibility of non-compensatory payments, direct payments. So in other words, donations to charity or not giving up the customer's cause of action. If the company voluntarily said, well, okay, don't make an order like that, that doesn't look good for our image, we'd much prefer to do it all voluntarily. I mean, deductible?
Well, I think you first of all have to examine the purpose of the policy in relation to the payments if it was done compulsorily, if they were compelling them to do it. And we're moving away from penalties now. We're moving into
I'm focusing on in lieu.
Well, yes, but you've got to ask what's in lieu of. If it was in lieu of something that was a penalty and had that policy, then I would say it's not deductible. But that really raises the question. Just simply raises the question: is what you're talking about in relation to customer redress orders actually a penalty which falls within the kind of
But if-
policy we're talking about.
But if the regulator, I'll try again. If the regulator said, we're thinking about making a consumer redress order against you, and one feature of it is that it may result in payments to customers who sustain no loss, and it won't require the customers who have sustained loss to give up their causes of action. In other words, exactly the same sort of terms that, in fact, they saw in this case, but done now under the heading consumer redress order, which I think could be done under the current regime as we looked at it. We'll have to.
I'm not sure about that, but anyway, that's
Okay.
just, if it was within the regime that they could compel these things,
So not compensatory.
so it must be, if that is allowed, it must be a form of penalty. Then it can't be anything else, can it?
So you say not deductible because it's.
If it was that, I'm not sure whether that
Is that
within-
punishment or not a penalty? I'm
Well-
using the words that the FTT that you just taken.
You have to ask the question: well, what is this thing that you were saying that they're compelling them? What is the purpose of it? What's the policy behind it? If it's not compensating customers, if it's giving them, then one assumes it must be some form of penalty. I mean, I'm not convinced at the moment that is allowed under the customer redress. I wouldn't accept that. It doesn't look like it on the face of it. But anyway, if it was, then, and they were to exercise that power, why would they be doing it otherwise than as a form of penalty, to encourage, to deter breaches of the regulations? Surely that must be why they're doing it. But you might have to examine that question, I think. It's not simply because it's compulsory, it's compelled, because often traders will be compelled to make payments, for instance, by the court. For instance, if someone sues them for breach of contract, and they say, well, there wasn't a breach of contract, we don't agree, and they fight it, in the end they lose, there'll be a court order that compels them to pay the money, but that wouldn't prevent it being deductible. So it's not the compulsion on its own that we're saying is the key to this. Similarly with the ombudsman, I suppose. Right, can I take you back in the supplementary bundle? Some of these points are actually covered by or at least there are terms in these documents which relate to what you've been talking about. What the relevance are is a matter, maybe for debate, but they're certainly covered. So if you go back to tabs 1 to 4 of the supplementary bundle, you have that. You have to go back, are actually the next stage of the process, which is the agreement. And can I just tell you, just for your notes, so that, to save you actually having to work it out, tab 1 is mis-selling. Tab 2 is payment differentials. Tab 3 is energy saving, CESP. And tab 4 is complaints handling.
And the two big numbers are the mis-selling and the complaints handling.
Yes, that's right. But I was going to take you to. We've looked at the letter in relation to complaints handling, and that's tab 4. But I don't think tab 4 has all the documents. Unfortunately, in the bundle we didn't necessarily have all the documents, I think, before the First-tier Tribunal even. It doesn't contain all the annexes, that's what I mean. Whereas the mis-selling document, which is tab 1, does have all the annexes. So you can see what the structure of it was from tab 1. As I understand it, I wasn't in the first-tier tribunal, but I understand it was common ground. It's always been common ground that all the transactions and the substance of all these are the same. There's no difference in the form of the documents, etc. But if I can just look at then tab 1, you can see that there is a settlement agreement. That's the first part of it, which is up to page 9, where it's signed. And it refers to the various annexes which contain drafts of press. You can see Annex 1 would be the penalty notice, which I don't think is actually there. Then Annex 2 is an agreed press notice. Explaining what's happened. And certainly the second last paragraph, you can see at the bottom of the page. Today's announcement, which was an announcement about the package of payments, is a clear signal to energy suppliers of the consequences of breaching licence obligations and the importance of taking action to put things right for consumers when they go wrong.
Doesn't say much. Doesn't say anything about the importance of being penalised.
Well, the signal is that these will be the consequences or could be the consequences if you don't comply.
Or being forced to take action to put things right for your consumers.
Well, be forced to take action which will do things. Wouldn't necessarily put things right, but exactly. But we'll certainly do things.
I was using their words.
Their words, yeah, exactly.
Can we just look at the middle of the page? Scottish Powers accepted these failings. It's put in place independent checks, etc., ceased doorstep sales. Had this not been the case, the company would have faced a higher penalty. So Scottish Power would have incurred, presumably, quite a few costs in making all those structural changes.
Yes.
But there's no issue, is there, over the deduction of those costs?
Not that I'm aware of, no. And that feeds into the. Well, we'll see when we look at the provisional notice and the final notice that there is a great deal of consideration of various factors in deciding what the penalty will be. And I think you can see that if you just move on.
Okay, so what's Annex 3 then?
This is explaining the. I think this is explaining what they're going to do in relation to paying the warm home discount payment, etc. So I think it's more detail as to exactly how it's going to work. So there's the warm home discount payment, and then there's the compensation payment beginning of paragraph 11. And then after that, there's Appendix A and Appendix B, which are drafts of letters that will be sent out to customers explaining. And that's where we get the bit about the apology. And if you look at page 16, under what this means for you, it's the second paragraph. So there's a number of letters, including a letter to those who are going to be might be benefiting from the compensation fund, which is on page 21. And then Appendix E is the actions that they will take to raise awareness about all of this. So you see briefing various consumer groups, etc. Dedicated phone number, etc.
So page 21, 22 is the letter you talk about the compensation, but this is to compensate customers for mis-selling.
This is all relating to mis-selling.
Yes,
exactly.
So where in that letter does it say that this payment does not actually compensate in the sense of removing any liability we might otherwise have to you?
When I was talking about that, I was referring to the I think it was 7.5 million payment.
Right.
This payment, there's nothing said about that.
But this would.
One would assume that it would at least discharge that amount of compensation. If they had further claims, they would. Yeah, yes. I think that's why the First-tier Tribunal differentiated the part of this 1 million payment, which actually was paid in compensation.
So that's the
From the rest.
554,000.
It was 554,000.
With and is that number because that's the number of reflected the customers who actually came forward?
That's what exactly. And the rest of the million had to be paid somewhere else. So
Right.
the point was they always had to pay $1 million. The only question was some of it would be paid by way of compensation, depending on how much was claimed, and some would be paid somewhere else. The balance was paid somewhere else. So that's why an issue arises about that payment, because it's kind of, in one sense, they're having to pay $1 million. In another sense, part of it's being paid as it happens, well, as it turned out, for compensation. So that was in the question, I think, which arose in the Upper Tribunal, was whether that meant that the 554,000 was deductible and the rest wasn't, which is what the First-tier Tribunal had decided. So the more compensation they paid, the more deductibility there would be. And then then Annex F is about the compensation fund and the details of how that's going to work. And then we have the notice of intention. So this is a provisional notice, it's sometimes called. And what you then find is that there is a consultation period. A consultation is asked for under this. And then there's a final notice. Now the final notice has a lot of similarities to this notice, except the main difference is that it also deals with the results of the consultation, if there were any results, which in at least one of these cases there was. Show you that. So what you have are, if you move on to page 35, section 5 of this, criteria relevant to the level of financial penalty. And there is a whole lot of different criteria looked at as to the level of the penalty.
So which
It begins on page 35,
35.
and it goes on to, you can see the various headings, it goes on to page 39. So it's all the usual factors: cooperation with the investigation, etc., degree of harm, duration of the contravention, etc. So all of that is going to the figure of the penalty.
The £1.
No. It's, in my submission, what it's doing, it can't be otherwise. It would be pointless going through all this process. What it's doing is going to the penalty that's behind all of this. Because, of course, if Scottish Power don't agree to the other payments, or they're unable to agree where the payments are going to go, because we'll see that that hasn't been settled at this stage. I mean, the recipient, who the recipient's going to be, has to be someone that Ofgem approves.
But I'm slightly
Then the penalty will come back into.
But I'm slightly puzzled by your answer to my Lord's question. I mean, if you go back to page 27 and look at paragraph 1.2, I mean, there the authority is expressing the view that in light of everything else that's being done, a nominal penalty of £1 should be imposed. You're saying...
But that's in the, because they've agreed to make contributions amounting to 8.5 million. And that's what they then say. If you look at paragraphs, section 6, you will see that the authority says, first of all, the authority considers the seriousness of the contravention, the degree of harm, warrant a significant penalty. That's 6.1. However, they place particular emphasis on the agreement to settle the investigation, on the commitment to improve processes. The authority has had particular regard to their agreement to pay 8.5 million to consumers, etc. So the structure of this, I would suggest, is that they're concluding in section 5, looking at these factors, what would be an appropriate significant penalty. But then they're saying because they've agreed to pay 8.5 million to consumers in a particular way, then they're able to, and in the light of that, they're able to impose a £1 penalty. They say in 6.7, authority considers the scale of these payments and measures will have a significant impact on SP's future compliance and a deterrent effect against future breaches. So that's how they've looked at it anyway. That's how the regulator looks at it. And then taking all the...
So deterrence but not punishment.
Well, in that they don't mention punishment in the sense of marking it. I think that is mentioned in a later document. But yeah, of course, deterrence is, well, I suppose one of the features of punishment is deterrence. You might say it. Depends.
It's one of
how you look at, yes, depends how you look on punishment. What's the purpose of it? Some people think it's deterrence. Some people think it's rehabilitation or retribution. I suppose you wouldn't really talk about retribution in this context. I mean, I think the equivalent is probably what they talk about, marking the seriousness.
But again, you're talking there about the aim of the regulator.
Of course, yes, yeah, I accept that. Obviously, the company is never going to have that aim in mind. Their aim is to further their own interests. And of course, when you look at actual penalty, you're also looking at the aim of the if you like, of the regulatory side, because the purpose of a company in paying a penalty is always going to be, to avoid, as you say, being a delinquent. I think
that's why it's so difficult to apply this principle as a interpretation of Section 54, because that focuses purely on purpose. You have to apply some sort of broader approach.
Yes.
To the scope of section.
Well, I think that's why Lord Hoffman said that you have to look at the nature. The answer is in the nature
and
of the payment.
he refers to nature and character.
Yes. Yeah.
But neither of those concepts is easy to get out of Section 54.
Well, unless you don't look at it being, and my learned friend says, well, it's an entirely subjective test, but of course it's not. We know that. We know that there are certain types of payments that are simply not deductible. Not as a matter of purpose, subjective purpose. For instance, the tax payments you've seen, because it's just a matter of logic, of circularity, that these are not deductible.
Yes,
nothing to do with the purpose.
Even that's easier to justify on the words than this.
Well, I'm not sure. You then have to interpret purpose objectively. You have to, in order to fit that within Section 54. I would suggest that there's always difficulty in explaining Section 54. People say it's objective, but subjective views are very important or critical or whatever. I think it may depend on the context. There are some cases where it is objective. There are certain, I mean, even Malnew and Drummond, I think there is a comment, saving an obvious case. They say it all depends on the intention of the motive of the
yes,
object.
but you can still, well, we don't need to get into a debate. You can still rationalise that by reference to what is treated as subjective purpose.
Well, yeah. Depends what you,
Anyway.
you say that's subjective, and then really we're getting into neurological and metaphysical debates when you talking about unconscious motives and whether these can exist. But in any event, that's what the House of Lords have decided in relation to this provision. So we are looking at the nature of the payment, and I agree. I'm quite accepting that it's not conclusive as to how the regulator sees it. Equally, it's not conclusive as to how the taxpayer sees it. So then, as I say, what they do then is they ask for there's a period for consultation, and these notices are published. So the consultation is with other than Scottish Power. In fact, I think there was a term. Sorry, I didn't take it, but where Scottish Power agrees not to participate in consultation. As a term of the agreement, it would be a bit unnecessary since they've already been consulted. So after the consultation, then there's the final notices, and that's tabs 5 to 8. And just again for your note, tab 5 is the mis-selling. Tab 6 is cost reflexivity. Tab 7 is energy saving CESP, and tab 8 is complaints handling. And if we just look briefly at the mis-selling one, since we've just been looking at the mis-selling notice. You will see that most of it is very similar, not possibly identical, to the previous provisional notice. But there is reference, I think in this case, it was said that, yes, page 124, they say that no representations were received. But there is but they were received in relation to one of the other notices. Could I just take you to that just to show you what's said. Page 161, this is in the energy saving notice. And you can see on page 161, 162 and 3, they set out what the result of consultation was.
This is in relation to energy savings.
This is in relation to the energy saving. And paragraph 1.3, four respondents submitted the level of proposed penalty was it might be too low. And then they're discussing the amount of financial gain made by Scottish Power as a result of their breaches. Now, what what's not totally clear is when they're talking about penalty here, whether they're referring to strictly the £1 penalty or whether they're referring to the global sum that was going to be paid. It doesn't appear that to make much sense, the discussion, if they're only talking about £1 penalty, because obviously that's too low in this sense on its own. And at the end of that paragraph, they say some respondents questioned the statement in the proposed penalty notice that the aggregate of the proposed penalty and the proposed amount of consumer redress is larger than the detriment suffered by consumers and the gain made by Scottish Power. So that was what was being said in the proposed notice. And the authority then says 1.4, the authority judgment is this statement is correct and the level of penalty is reasonable in all the circumstances. Again, they must be, so slightly confusing, but they must be talking about the aggregate here in assessing any financial gain.
No, they're just saying the £1 penalty is reasonable in all the circumstances.
Including the other.
Indeed.
Yeah, maybe that's the... But what they're comparing, as I understand this, is what the financial gain would have been with the aggregate sum.
Indeed.
So the idea is that will be greater than the gain. Otherwise, they would be benefiting from their wrongdoing. I think that's the point that's being made. And then there's more discussion about the financial gain, how you determine that in paragraph 1.5. And 1.6, in relation to the point about sending a clear signal about the importance of compliance, the authority is satisfied the level of penalty is reasonable in all the circumstances of the case and addresses the seriousness of the contravention. Again, the same point as my lady made, that must be referring to in the end, the aggregate of the two payments.
Well, no, it's saying the level of penalty of £1 is reasonable in all the circumstances.
Yes.
Including the consumer redress
Yes.
element.
But it's reasonable in sending a clear signal about the importance of compliance.
In all the circumstances.
In all the circumstances, yeah. The point I was simply making is that just looking at £1 wouldn't be sending a clear signal, but the other payment would be. So that is the, if you like, the end of the process. That's the final notice of decision to impose the penalty, etc. Can I then take you to the First-tier Tribunal's decision? I hope this, I'm not intending to take a long time with this, but I just wanted to draw your attention to the, what I would say, relevant paragraphs. First of all, paragraphs 11 to 13, they set out extracts from the policy statement on consumer redress. And paragraph 17 is a discussion of the interaction of penalties and compensation of other redress payments. And then paragraph 19 is an extracts from the enforcement guidelines.
Have we got those?
Yes, I think,
So now we've got the earlier guidance, the FTT, well,
I think the ones
later in time, but got the early.
I don't know if
I'm not sure we've got these.
the enforcement guidelines 12 September 2014 is tab 21
Oh, thank you.
supplementary bundle. And the important what significance of this is the second paragraph quoted. It's important to appreciate that settlement in a regulatory context is not the same as a decision, settlement of a commercial dispute. Off-gem settlement is a regulatory decision taken by us, the terms of which are accepted by the company under investigation. We must have regard to our statutory objectives in agreeing with terms. Settlement is a voluntary process. There's no obligation to enter into settlement discussions or to settle, etc. And then the tribunal commented on this in paragraph 20. The distinction drawn between a commercial dispute and settlement rather false, because they said each side will have different principles or requirements. Of course, that's true. But in my submission, the point that the regulator was making in these guidance is that they are not simply doing what you might call a horse deal. They're not simply free to settle any way they like. It's rather like the revenue settlement strategy that they have to settle cases in accordance with their statutory powers and objectives. So they're simply emphasising that they are acting as regulators. Of course, the other side is acting as a commercial operation, so they're deciding what they're going to do based on their own commercial interests, of course. And then they do say that then, from Mr. Sinclair's evidence, that they accept that the 2014 guidelines, which they've set out, represented the practice in the relevant years preceding the publication.
That finding appears to refer to the September guidelines rather than the policy statement, which is referred to at paragraph 11 onwards. And we spent quite a lot of time on the policy statement. This is a query I raised yesterday.
Yes, it does. Well, on taking it literally, that's what it is referring to. Yes, but for my purposes,
we've got no. I mean, going back to the November 14 statement, we've got nothing else, and there was apparently nothing else in front of the FTT.
No.
Did you look at paragraph 30 of the FTT's decision?
That this was a change in the approach. Yes, and I think that's the history. I think, and it may reflect the fact that somebody had this idea at some point that's how they could do it, because it's not, there's nothing in the legislation that specifically deals with this.
But you say, in spite of that change of approach, for tax purposes, there in fact is no difference, no change.
There's no change in the what Ofgem were trying to achieve as regards deterrence and etc., marking the seriousness. They're still acting as a regulator, taking a regulator. That's why I was just taking you to the guidelines, which they make clear that there's no change in substance. The only change is where the payments are going to go. I would suggest, submit. In fact, the change actually suggests that they're simply trying to achieve the same purpose by different means. Indeed, they have to be doing that, because the only way that they could justify entering into these agreements is if they are properly justify entering into these agreements, as if they are furthering the purposes of the regulator in the same way that imposing a penalty would. That has to be the underpinning, statutory underpinning for entering into these agreements. That's why they are valid, why they are within the powers of the regulator to enter into them. They wouldn't, I would suggest they wouldn't have the power simply to come to an agreement with Scottish Power that instead of paying a penalty, we'll accept some payment from you or some payment to someone else.
Might that have something to do with why there is a £1 penalty
Yes.
rather than no penalty?
It may be that they felt that they had to have a penalty of
Yeah.
some level.
Because it's perfectly arguable that a penalty of nil is reasonable in all the circumstances if you pay 18 million to specify.
But it might be said that's not a penalty at all if it's nil.
Well,
And I think one of the significance of having the penalty at all is that it triggers all the statutory provisions in section 27A, which require the notices to be given publicly, etc.
so it engages the consultation process, for example,
Yes.
maybe in particular.
Well, it's that, but it gives clear power, in fact, obligation on Ofgem to publicise this by way of the notices that are provided for in section 27A, in subsection 3 for the provisional notices and subsection 5 for the final notices.
If they decided to make a consumer redress order, don't they have similar?
Oh yes, because that's a statutory provision, but they remember they didn't have the power to do that.
I know, but I'm trying just for a moment to take a slightly broader view than the particular factual scenario we face because of the timing of this case. But in general terms,
Those would be subject to the same, I think,
yeah.
the same kind of publicity, yes. But the question I was addressing was why were they doing this now? Why were they doing this at this point? And why did they have a £1 penalty?
It's a nominal penalty. I think they call
It's
it.
nominal, but it's still a penalty and it does trigger the statutory provisions. I think that is the thinking behind it. And it may have been thought doubtful that if they didn't have a penalty, well, one, it might not have been within their powers to do it at all. But secondly, more importantly, they may not have been empowered to publicise it in the way that they were required to under the Act when there was a penalty. At least there would have been some doubt, I think, as to whether that would have been appropriate. So there is a significance to there being a £1 penalty. It is part of the whole package. So then I was then going to take you to paragraph. Yes, I think we've looked at 17 to 21. If we then look at 29 to 31, this is a brief summary, just perhaps for your note, of the history. I think your Lordship has pointed to paragraph 30, but of the history of moving from pure penalties to these kind of arrangements. And paragraph 35 sets out from the company's point of view why they settled. And my learner friend, I think, is taking you to that paragraph. And then if I take you on to paragraph 136, and that is in lieu of a penalty. That explains why the FTT believed that. Can I just make one point for completeness about National Grid and Gemma? As the First-tier Tribunal said, this was an appeal from the Competition Appeals Tribunal, and the jurisdiction of the Court of Appeal on an appeal from the Competition Appeals Tribunal is very different from the jurisdiction of an appeal against the penalties in the Electricity Act. Your Lordships may have been involved in appeals from the Competition Appeal Tribunal, but they under the Competition Act 1998, which was in force at that time, there was an appeal against the amount of the penalty, and there was also an appeal against the substantive decision as to whether there was market abuse or whatever on a point of law.
Yes, you mean there was a full
appeal
against the amount
of the penalty expressly.
I think you're drawing a distinction there from the possible appeal that could have been made.
Yes.
In this case,
which seemed to be mainly procedural.
Yeah.
Or in relation to the timing. But anyway, I only raised that. I don't say that the appeal is any significance, but my learned friend did say it was an important part of the case. So yes. I thought I ought to just draw attention to the fact that that's not a good analogy, that case. So it's 139 is the core of their reasoning, I think. Seems to us the same public policy, which they refer to as public policy, I'm sorry, Muller, which denies the deduction for a punishing non-compensatory penalty, also denies the deduction for punishing non-compensatory payments which arise from a breach of statutory conditions, which are made in avoiding a larger penalty under the aegis of the body that would have imposed the penalty. The non-deduction policy inherent in the statutory provision which permits the authority to punish must also be inherent in the ability of the authority to extract other payments instead of or under the threat of imposing a penalty. Thus, even if it were the case that, because the redress payments were not imposed by law, they could not be penalties, the same policy considerations, the concern over dilution of the deterrent punishment by allowing deductibility applies. We would endorse that reasoning. And then we have paragraphs 143 onwards are, as I said before, a summary of what happened in each particular case. And particularly, if Your Lordship looks at paragraph 156 in relation to complaints handling, they say the round sum payments of £73 to each customer. That indicates to us that they were not calculated to compensate the recipient for loss actually suffered, particularly as SP was not released from the payments of compensation it would otherwise have to make. We conclude it was not compensation. So that was the finding I was referring to about them not being released from payments of compensation it would otherwise have to make.
What's that based on? That finding about not being released?
I think it was based on some either the documents. Yeah. Well. Okay. Yeah. Yes, it's on. Yeah, sorry, it's in the complaints handling agreement to settle, page 93 of the bundle, little f.
So the supplemental bundle.
The supplementary bundle, yes, sorry, page 93.
Settlement of claims by non-qualifying customers. How do we read that?
Yes.
Are qualifying customers the ones who get the warm home discount? And so on? No, they're the ones who actually complained or had late bills.
You say you support the. Sorry, are we still looking at?
Doesn't support
Yes,
Snowden.
I was just looking. This is dealt with by also by the Upper Tribunal in its decision, paragraphs 91 to 93. I think it's paragraph 91 they discussed.
So the payments actually went to qualifying customers, which is back on the supplementary bundle is exactly what 4B says. And 4F doesn't seem to support the FTT's finding.
Yeah, attention is drawn to O as well.
Sorry?
O, little O, which is over the page. Ensure that payments made to qualifying customers are additional to and do not replace or offset against WHT or other payments these qualifying customers would have received in any event.
What are you reading from, sorry?
Sorry?
What are you reading from?
It's O. It's on this, it's
Page 94.
page 94.
Oh, of the...
Sorry, of the supplementary bundle. Page 94, O, little o, in the same paragraph.
I'm not sure that's the same thing either. They don't replace the home discount payments that they would have received in any event.
Or other payments that they would have received. In
Well, it's not the same as potential compensation.
I would submit that is all of this is intended to ensure this is on top of anything else that you might receive. I mean, there's nothing, putting it another way, there's nothing which says it discharges Scottish Power from.
But we've
any
also
obligation.
not been shown anything that requires recipient customers to sign something saying we give up our rights to make a claim,
No.
which is exactly what you'd expect if they were being asked to receive something instead of.
But I mean, the other problem with this is that this payment is not actually in respect of anything. So you couldn't identify something that they're giving up. It's not compensation for anything in particular. It's simply being paid to these people because they're qualifying customers at the relevant time.
Well, it's to pay them for failings in relation to complaints handling.
In general terms, but not in any particular. Not in any particular. It's not saying, well, this is because you've suffered particular loss or anything like that. It's deliberately not in respect of any loss. So it would be difficult to see what they'd given up. I mean, you'd have to say it was any complaint, any claim at all in relation to as your lordship said, any claim at all in relation to these defects. But that's not what's being said. Just the company can say that we've made terrible mistakes. We want to offer redress. We'll pay all our customers £50. They could do that, but that's not releasing them from any obligations. If one customer says, "Look, what you did has caused me £10,000 of loss," it wouldn't release them from that.
Is there
It wouldn't.
Is there anything in the regulations more broadly which would oblige an energy supplier to compensate customers in the event of breaches of, for example, complaints handling? Or is there any regulatory claim they could have brought?
I'm not sure about that. I think they could certainly bring claims, obviously, in the courts or in the small claims court or to the ombudsman.
Or perhaps the other way, could the regulator have imposed an obligation to make compensatory payments in these circumstances?
Yes.
There may not be a contractual cause of action.
I'm not aware of it, and I assume because of the consumer redress provisions being brought in that there wasn't anything before that which allowed them to. That's why they used this mechanism before they had the consumer redress payments or anything like that. I think the answer is no, but I'm going to be corrected. I've just been taking it to the paragraphs up to paragraph 157. And then, as regards wholly and exclusively, that's dealt with in the following paragraphs under the following heading. You can see. It's also dealt with at paragraph 113. Although that's a slightly different point, I think, in 113. They're talking about the purposes of the actions which gave rise to the payments in 113 as being wholly and exclusively for the trade. So that they're not addressing 113 the purposes of making the payments. And then in the section beginning 158, this discussion only applies, they say, to the payments we've found to be compensatory, or if we are wrong in the conclusions in relation to the issue of the penalties and how that works. And what they're discussing in this section are, first of all, the actions that gave rise to the payments. In other words, what they were doing in their trade. That's paragraph 162. Whether they were unavoidable. So that they're then in 164 addressing the McLaren kind of question. Was this wholly outside the trade? Because I think at that stage there was an argument by the revenue that in some way this is outside the trade. And there is a rather, I think the sentence beginning paragraph 164, possibly something's gone wrong with it, because it seems to have too many negatives, as far as I can see. I think it may be intended to say we do not think that it can be said that all of Spell's failures were wholly unavoidable. It's a little unclear. But the next part of it seems to suggest that they are saying that Ofgem found that some of the breaches could have been avoided by setting up robust practices. So they're dealing with that up into paragraph 168. And just to note, in paragraph 167, they make the point that the infractions were plainly serious, but they didn't lead to the destruction of the business. So they didn't think that they were the kind of payments that were being dealt with in McLaren. And what they then conclude in 171 is, on the basis of our conclusions as to the trade conducted by Spell, the expense is incurred wholly and exclusively. So what they seem to be saying there is, it arose out of the ordinary activities of the trade. What they're not addressing in this section is the question about what the purposes were in making the payments. They did address them earlier on, as I think I pointed out in paragraph 35.
I'm not sure that's true, is it? In 172, we found the other payments were not deductible or policy grounds. If we are wrong, we would find that Section 54 did not preclude their deduction. That seems to me necessarily to involve a finding that leaving Lord Hoffman, etc., on side, these payments, expenses incurred wholly and exclusively for the purposes of the trade.
Well, that's what it should involve, but it doesn't seem to expressly involve it because what they're discussing in this section is the conclusions as to the trade, which is in 171, which is, are these activities part of the trade? In other words, does it come out of something that's simply part of the trade, so just carrying on activities, just doing it badly, or not as well as they should be doing it? Or is it something outside the trade? Which is why they're talking about McLaren. And
well, you can't get away, Mr. Ewart, can you, from the very clear statement in 172?
I'm not trying to get away from it because it is all subject to the penalty. They say expressly, leaving aside the question of penalty.
I mean, to be absolutely clear, my reading of this is that absent the penalty issue of policy,
yes,
they
would have decided. They would certainly have decided that.
They would have allowed the payments and to the under
absolutely
wholly and exclusively, and to the extent that you can't identify an error of law, that is something that holds good in this court.
Yes, yeah, I'm not disputing that. I'm simply pointing to the line of reasoning that they adopted in this.
But the only, as I understand it, the only error of law you assert is relation to, if you like, the policy issue, the penalty point.
I don't think they didn't make an error of law in that. Well,
no, sorry,
only
they do. You say they do as regards the 554.
That's more a question of analysis as to.
Okay.
Yeah.
Sorry, but you're not suggesting that there is any error
in this. No, we've never appealed on the grounds or whatever we have to do, respondent's notice, on the grounds that that's what. And then finally, just for completeness, I thought I would take you to the passages on inevitability so that you have those in your my learned friend from time to time says, well, these were inevitable, these breaches, and that's not what the tribunal found. First of all, it's 112 where they deal with this issue, or they make statements about it. And they say, we find the payments were a consequence of not meeting the standards required of energy suppliers. They're not commenting on whether they're high. We find that infraction of the standards is not uncommon, but the serious breach, as was the case in relation to the redress payments, is less common. We consider the breaches of the CO2 and complaints handling were practically almost unavoidable. So not unavoidable, but practically almost unavoidable. We're not able to say the same about mis-selling or cost reflexivity. And then paragraph 114, they accept it wasn't inadvertent, it was not inadvertent or accidental. I think maybe they
Well,
should be
somewhere between deliberate and inadvertent.
yes, somewhere between the two. Whatever that means.
Well, I thought I read that as meaning it wasn't done with the intention of breaching the regulations,
No.
but it wasn't involuntary. I mean, it wasn't done by accident. In a sense, it didn't.
It wasn't something.
They were conscious decisions to do what was done,
Yes.
but not with the intention of breaching the
I think that must be, yes, I quite agree. And then paragraph 144. It makes the same point, I think. Ofgem said it regarded the breach as serious, but while not accidental or inadvertent, were not from conduct intended to breach. That's exactly the same. And then paragraph 159, and this explains why I think, I would submit, why they're looking at unavoidability as a concept. It's because of the McLaren case, a deliberate activity which was contrary to contractual obligations and the rules and regulations, which was not an unavoidable consequence of carrying on a trade, which could lead to the destruction of the trade, not an activity in the course of the trade. And that's why they deal with it in paragraph 164 that I've taken you to, where they say, we do not think that it cannot be said that all Spell's failures were wholly unavoidable. The making of mistakes from time to time in the conduct business is an ordinary occurrence. We take note that it was not a belittle market for product liability or professional indemnity insurance. We take the UT's use of unavoidable to flow from the description of the libels in Herald, but in Herald the libel actions are described as almost unavoidable. And then they go on to talk about libel. So that's what they said about it being unavoidable. We would submit their conclusions are that these were serious breaches. They weren't deliberate, but they weren't inadvertent either. And common sense would tell you that must be the case, because you can't have a regulatory regime which would punish someone for something which they cannot avoid doing. It would suggest the corollary of that would be that it is impossible to comply with the regulations. And no one is suggesting that that's the case. Can I just end by very briefly just going through my learned friend's
Just before you leave,
Shows.
before you leave the FTT, can I actually take you a little back through the paragraphs where the FTT deals with the question of penalty and punishment? Because we didn't sort of look quite as closely at perhaps at that as I think we might need to. It sort of starts at page 109 of the bundle, where under the heading penalty and punishment, and they record Mr. Goldberg as having submitted that there were 3 conditions to be satisfied for the expense to be non-deductible. It must be a penalty, its purpose must be to punish, and then there must be a rule. Now, I'm not interested in whether you agree or you don't agree with that at the moment, but that seems to start in the FTT's mind a distinction between the concept of a penalty and something which punishes. Because otherwise, it seems to be different.
Well, in Mr. Goldberg's mind.
Well, yes, but it certainly is in Mr. Goldberg's mind, because that's his submission. But it seems to be the FTT starts to run with this.
Yes.
Because at 122 they say they're going to look at it separately. And they go through an analysis of Lord Hoffman's judgment. And at 128, he, I think, drew our attention to the saying you shouldn't be interpreting his words as if they were a statute, which is fine. And then they introduce at the end of 128, they say the issue in this appeal is whether such a policy can be read into the Electricity Acts or into the Taxes Act, to be so as to deny deductibility of the redress payments. If they were punishing penalties, it seems to us that such must be the case. So they introduce this concept of punishing penalties. Now, if we move on, they then go on again to acknowledge Mr. Goldberg separating penalty and punishment, and they have a little discussion about what the essence of a penalty is, etc. And then they separately look at the concept of punishment. And at 132 through to 134, they talk about Gemma intending the obligations to make the redress payments to be punishments. And that was, again, a paragraph you asked us to look at. So you're saying, or they are saying, that these payments, the redress payments, although not labelled a penalty, because they're a penalty with a capital P, they're clearly not.
No.
They were punishments. Right? And then we go through to the section about in lieu of a penalty that you invited us to read, and the central bit, as you rightly said, is at 139. And they talk about Lord Hoffman's reasoning resting on public policy. Well, we've had a debate about that. I'm not interested in that at the moment. But it's the next sentence and what follows. I just wanted to sort of get your comment on. It seems to us that the same public policy which denies a deduction for a punishing non-compensatory penalty also denies a deduction for punishing non-compensatory payments which arise from a breach of statutory condition. So they are equating, I think, the £1 penalty, punishing non-compensatory penalty, with the 17,999,000, etc., or whatever it is, being a punishing non-compensatory payment, or are they? I don't understand the difference. What are they talking about there? A punishing non-compensatory payment which arises from a breach of statutory conditions.
Well, they're obviously, in concrete terms, they're referring to the payments in the present case, that they are punishing because they perform the role of punishment to deter and etc.
So they are,
and they're non-compensatory because the tribunal thought there was a distinction which we have challenged between whether they turn out to be compensatory or not. So they're saying
the bulk of the payments are non-compensatory, I think, in their terminology.
terms. Yeah.
So they're saying that, and they say, which are made in avoiding a larger penalty under the aegis of the body which would have imposed such a penalty. So what they seem to be basing there, and then they go on to say, the same principle must apply. So what they seem to be basing their read across from penalties stricto sensu
Yes.
to the rest of the payments is the concept of whether they are either a punishment or intended to be a punishment. I mean, is that how you read this?
I think they're saying that a 17 million payment in the way that it was structured would have the same purpose and policy as a 17 million penalty if that had been imposed. If the company...
So does punishment become the leitmotif of this decision? Or of this regime that you're asking? Because you're asking us to adopt this.
But I think that's because... Isn't that because that's why penalties, that's why the policy that Lord Hoffman talks about in penalties leads to the conclusion that it shouldn't be diluted. Because it is a punishment. The punishment having different aspects, deterrence, etc. But that's what I would suggest that's what underlies the policy that Lord Hoffman is suggesting. That's why you shouldn't be able to share it with people, because it is a punishment. You shouldn't be able to share your punishment
so where
with the rest of society.
Where is any evidence or finding that the regulator intended these payments as punishment?
Well, punishments in this, I don't think they don't use the word punishments, but that follows from what they summarise in paragraph 134, I think, that they're regarding it as being delivering deterrence. Non-compliance should cost more than compliance to ensure future compliance. Well, that's the aim of a punishment. One of the aims of punishment is to deter future wrongdoing of the same kind. Their statement.
So you're saying that
penalty.
you're saying that the question, the result for tax purposes, depends upon the regulator's intention as regards punishment, however, whatever they may say or not say.
I'm not submitting that it entirely turns on the subjective intention of it turns on the intention of the regulator. It really must turn on the nature of the payment, because that's what we're looking at. I think that the First-tier Tribunal we're identifying the nature of the payment from that.
If it turns on the nature, what is the critical identifying factor that makes it non-deductible? Is it that it's punishment?
That it is in that. I go back to that word is not anywhere. It's not.
I know that's why I'm asking you the question.
But it's punishment in the sense of being operating as a deterrent, etc. It's not. It's something that they wouldn't have had to pay otherwise, and it's something that is designed to deter them and other people from doing this. So, it being publicised that because of these breaches, they had to pay £18 million. That is designed to be a deterrent. But the reason I say it is maybe slightly different from the way in which the First-tier Tribunal put it. I would say it's because it arises out of the same statutory powers of the regulator. They're acting just as much as a regulator in the same way when they're agreeing these payments as they would be when they were imposing a penalty. So if we just take just imagine they got to this stage and the company said, no, actually, we don't want to pay money to this trust, we don't like them, and therefore we'll accept the penalty, you'll impose the penalty. They choose to impose the penalty. I think everyone would agree in those circumstances that was not deductible. I think even my learned friend would agree that if the company chose, because they have a choice, as my learned friend says, either to make the payments or to accept the penalty that will be imposed on them. So if they chose the penalty, then it wouldn't be deductible. If they choose to make the same payments to someone else, we would say it has the same character. It's the same nature in this payment because it's performing the same functions. It may perform some other functions and it's going to obviously help people, but I suppose you might hope that the consolidated fund might help people as well, but only in a more general sense. It's more targeted in helping those who are affected, looking at it very broadly by the breaches. But there's nothing odd in regarding reparation payments to a victim as being part of a punishment. Many cultures that is the punishment, isn't it?
See, well, I mean, your submission is obviously that irrespective of what it is either called or indeed
yes.
actually in law forms, namely a penalty in the strict sense, as the regulations
Yes.
enable to be imposed, you treat it as the same because at least one of the motives behind, or one of the purposes, objectively speaking, behind it is punishment.
Yes.
Or deterrence.
Or deterrence, yes.
Deterrence from being punished. You know, in other words,
Deterrence from someone. Yeah, so exactly. Well, what it's the message it's sending out is that if you, either Scottish Power or some other company, does the same thing, then they will be subject.
Yeah.
They will have to pay.
I mean, punishment.
Sizable sums.
Yeah. I mean, deterrence is wider than punishment in the sense that deterrent applies to other people as well. In other words, you know, if they see that you're punished, they won't do it either.
Yes. Well,
But
we can argue about the philosophy, but it could be regarded as one of the features of any punishment. That it's pour encourager les autres. You know, that's why they impose serious heavy sentences on knife crime to discourage other people from engaging in knife crime.
It's a very
part of it.
It's a rather uncertain dividing line or world, isn't it? To ignore what the regulator actually says it's doing and recharacterize what it actually says it's doing as something akin to.
Well, I don't think that's fair. That the regulator is making clear in these notices that it regards this as being a form of deterrence for other people. That's what it thinks it's doing. I don't think it's right to say the regulator thinks it's doing something else. We would suggest that that's exactly what the regulator thinks it's doing and what it should think it's doing. Because it has to be operating this within the statutory regime. I mean, that to further the purposes of the Act, to ensure compliance with the regulations. That's the reason the regulator's there. That's what it's doing. So it's not there. Leave aside the customer redress payments, which are not an issue. But before that came in, it wasn't any part of its role to compensate customers per se. It was to ensure compliance with the regulation, various regulations. So I can deal with the 8 features really very quickly because we've already, I think, discussed most of it. The first feature was that they were made under agreements that involved choice. But the choice, of course, was between making these payments and having a penalty imposed. So, one might say that if they chose the penalty, then equally they were exercising choice. This idea of exercising choice in my submission doesn't get you anywhere in this. The choice shows you, though, that these are alternatives, the penalty and the payments. It lacked the element of compulsion, I think was the second one. But in my submission, that's a wholly unrealistic view to take about what happens. There is an element, one might say, of compulsion, in that if they don't agree to this, then they're going to have to pay the same or similar amounts by way of penalty, or they will be imposed on them. And it's of no relevance that they could possibly appeal against it, the penalty. I mean, it's perfectly open to them to, if they thought that they hadn't breached the regulations or hadn't breached them very badly, to have done just that, except refused the offer and appealed against the penalty. But they didn't do that. They arise from the normal course of relationship between the consumer and the supplier. Well, that's exactly the same position with the penalty, of course. And it's exactly the position that was in Von Glen, if you remember, on Von Glen. They were trading in a completely normal way. The problem that they had was just that they couldn't prove the end use of their goods, that it wasn't going to the enemy. Nobody suggested they were doing anything wrong in their trading. They were completely innocent. They're unavoidable. Well, I've already said that that's not the finding that the tribunal made. They're made to benefit consumers. Well, that's true, but we would say irrelevant. And they're payable to remedy trade wrongs, not as a fine or penalty for breach of law between state and taxpayer. Well,
and you say the reason that the fact that they are paid to benefit consumers directly or indirectly is irrelevant. You say the only relevant test is whether they would have been paid absent the. Is that right? Whether they would have been paid absent the threat of a penalty from the regulator.
Yes. If they can say, well, we've already made these payments and we made them completely of our own volition, nothing to do with a threat of penalty, then that would be a different situation, I accept.
And you'd say presumably so if at the start of an investigation, before the regulator gets around to sort of actually mentioning the P word, the company says, oops, we'll make some compensation payments, yes, fine, deductible. But as soon as the regulator mentions the P word,
well, if they're
like,
saying
sorry, no deductions are off the table.
If they say to the regulator, if we make these payments, will that satisfy you? Will be a penalty? Then that might be, and then they agree to do it. The problem would be then that the regulator in practice here, I don't think they would agree to that, because they would not have the penalty aspect. If they went away and did it themselves and voluntarily without talking to the regulator, then of course that's different, because there isn't the same connection with the penalty. But in this case, there is, it's a clear case. There's no doubt that they've decided to do this because the alternative is a penalty. I can see, you might say, difficult cases arise if they do all these other things. I don't know in practice whether that ever happens, but if they were to suddenly voluntarily set up a compensation scheme.
Well, if penalties work properly as a deterrent, then it may well be, having seen somebody else being penalised, they will take action to avoid it.
Well, exactly, but that
would be fine. That would be deductible.
That would be fine, be deductible, but that would show the value of the penalty, or the alternative, the non-penalty, if you like. That would show that the policy is working, of encouraging others to do things. I mean, the policy is to encourage people to do it voluntarily, to not to have to go through a regulatory process. My submission. But the payments, I mean, who benefits? My submission is irrelevant. I mean, the payments to the consolidated fund clearly benefits, the whole of society, don't they? In principle, at least, whether in practice they do, but in principle. So it's difficult to see why the fact they benefit particular consumers makes any difference on its own. He says it's not paid to satisfy the wider requirements of society or business interest. But in my submission, it is. That's the whole point of our argument, that it's being agreed to by the regulator and paid to satisfy the wider requirements of society. And it's shown by the fact it's publicised in these notices that you've seen. And the point's being made, look what happens to you if you break the regulations. And his final point was it's not paid in lieu of a penalty, in lieu of rigmarole. I'm not quite sure what he meant by rigmarole, because the stage we've got to, you've seen, is that they have admitted liability. And they've accepted that. If it was a case where they didn't admit liability, then they wouldn't get into all of this. I would quite accept, though, that the reason it's being paid, or the reason they accept this alternative means, is because it's less bad from the point of view of the company, public relations. So, sorry, I'll stop there. I'm taking a bit longer than I thought. Can I allow Mr. Chacko just to briefly address you in relation to the very narrow issue, the issue of...
Okay, whilst Mr. Chagler is addressing it, could you just give some thought to what your position on consumer redress orders, which I appreciate are not directly relevant to this case, but the question that we rather left unresolved earlier in the morning about whether consumer redress orders can only be made in favour of people who have suffered identifiable loss, or more broadly.
Yeah, particularly given the Ofgem, what it's worth, the Ofgem.
The difference between legislation, perhaps, and the regulators' statement.
Yeah, and it may be you aren't able to, as it were, depending on how long Mr. Chacko is going to keep us occupied, you may not be able to come to some landing on that. But can you give it at least some thought and
I will.
See where we go?
I have to warn you that I may feel that I'm not representing the regulator, and I wouldn't want to say things that would prejudice them in later litigation or anything like that. So,
well, by definition, since you're not representing them, I don't suppose you would.
No,
but,
well,
nevertheless, it would.
Depends what your lordships might say, a ladyship might say in judgment about them. But anyway, I will give it some thought. Yeah.
Thank you.
So, if you don't mind, I'll just find it easier if Mr. Chacko just moves up here. It's a bit nearer.
Yes, I think Mr. Chacko, the suggestion was you might, subject to Mr. Goldberg, step a row closer.
Yes.
I've got no objection.
Right.
Thank you, my lord. So I'll be addressing you on whether the Upper Tribunal was correct to deal with each set of redress payments for any given settlement in the round, treating it as similar to a penalty, rather than looking at each element and deciding whether or not it was compensatory, because that's an area where the Upper Tribunal differed from the First-tier Tribunal. If I may, I'll first take you to the way the First-tier Tribunal dealt with this, and then the way the Upper Tribunal dealt with it, before explaining why we say the Upper Tribunal was correct. So in the first-tier decision, the distinction between compensatory and non-compensatory punishments is talked about at 130 and 131, where they say, essentially, while they go on to say that all of the redress payments are punishments, they say only the ones which are non-compensatory are in the nature of penalties. So I might ask you to read 130 and 131.
I'm not entirely sure I find the football analogy that helpful. I mean, if your forward is in the penalty area and is about to shoot and gets felled by the defender, and you're awarded a penalty, you get the chance to have the shot he was denied.
So it may be called a compensatory.
Yeah, I mean,
I
I don't want to get
I'm
distracted,
I'm not,
but I'm not
and we
entirely
also
sure that's...
we don't uphold this distinction. So I think they may be making the point that the word penalty can be used in quite wide senses, but they don't think it applies to something which is compensatory.
Yeah.
They then apply that to mis-selling at 146 to 149.
Yeah.
And then I think the only other set of payments where it seems to have even been seriously suggested they might be direct compensation are the ones at 156.1, where they held that the £73 to each qualifying customer under complaints handling were not calculated to compensate, which you've been to that passage.
Yeah.
And then in the Upper Tribunal, I'd say the relevant passages are first paragraph 68. And then take you to 88 and 89.
Yep.
And finally, 98 to 100, which are where they overturn the First-tier Tribunal in regards to the 54,000. So I'd say it's not the case that they just dealt with everything together. They looked separately at each settlement. But for each settlement, they concluded it had the same essential nature and structure, which is that you had an investigation, the investigation was settled, which involved Scottish Power conceding they were at fault, and that settlement was made on the basis of an indicative total penalty that was known to the parties beforehand. That penalty was then redirected towards customers and general consumer benefit. And those last two points, I think, are, I mean, in a way, that goes throughout our case, not just on whether or not the 554,000 was deductible, but I think we say that is the right way to look at what has happened here, and that is also what the tribunals found. It was the right understanding of what was being done here. It's most obvious with the two later settlements. You've seen, I think, you've regularly been to the letter at tab 20. There's a similar letter at tab 18 for CESP. But looking at the one that you looked at before, page 204 of the supplementary bundle. And I'm looking in particular at the next page, 205 of the options. So you see the structure for the later two penalties. There's an indicated total amount. There's an offer to discount that amount, and if you fulfil the options in the box, you genuinely get a reduction from 23 million down to 18 million if you act promptly enough. We say it's not then further discounted. What then happens is Ofgem agrees to let it be paid elsewhere. Remembering the comments in Von Glen, which are, even though they've been explained by Lord Hoffman, they're still true, the comments in Von Glen. Scrutton's line, Lord Justice Scrutton and 572 describes the penalties there, the fines, as unfortunate incidents after the profits have been earned. And Lord Sterndale talks about how you bear this, it's intended to be borne by you personally. It would seem surprising to say that up to the end of that box on that page, these are unfortunate incidents after profits have been earned. But if you take the next option and agree where the sum that the regulator wants from you is going to be paid, it suddenly stops being an unfortunate incident after profits have been earned and is a component of your earning of the profits. Because we know that this is still a penal settlement that was dealt with by the First-tier Tribunal at 115 in one of the findings Mr. Goldberg asked them to make and they refused to make, where they said the request being to say the redress payments did not engage any statutory process, and they said, well, no.
Sorry, where are you?
115 of the first-tier decision.
Yes, but sorry, I thought you introduced this by saying that the FTT had found that this was still a penal, was the word you used.
Yeah, what I'm meaning there, I'm saying that this settlement is still an exercise of the statutory power, and it's the power to punish. It's not, you don't have two separate things going on.
Okay, we need to be careful with language.
Yes.
Do you equate penalty and punishment, or do you distinguish between the two?
I think we say for these purposes you don't really distinguish them. If you have a regulator which is authorised to punish you, the fact that it has various means in which it may punish you one of which is headed up penalty in the Act, isn't a relevant distinction for the principle in Von Glen and McKnight. In the most literal, in the sense of the statutory penalty, obviously there are punishments you can get from the regulator which are not statutory penalties. That's exactly what has happened in under this settlement agreement. But whether you describe this as a punishment alternative to a penalty or another form of penalty, I don't think actually makes that much of a difference. It's clearly not a statutory penalty. We know it's not a statutory penalty. But, in a sense, the main dividing line between us on this is whether it matters for the principle of, in McKnight and Von Glen, whether what you end up with is a penalty under the statute. I mean, there is a discussion, the closest thing I think there is to this is the discussion of alternative punishments in McLaren. That's paragraph 70 of McLaren.
So, just to be clear, so if the regulator has power to force you to pay compensation to customers for identifiable loss in circumstances where you wouldn't ordinarily do so, you wouldn't voluntarily do so, there's no indication you would do it voluntarily. The regulator says, I force you to pay compensation to people who suffered identifiable loss. Is that punishment?
I would say not necessarily, unless I'm told that isn't. I think it isn't necessarily. I think there are difficult cases, divisions, distinctions to be drawn, because regulators have a range of functions, some of which are punitive, some of which are about facilitating compensation. They, similarly, obviously, if you go to court, the court may force you to pay sums in compensation which are not intended to be punitive.
But, so you say that being forced to do something which you wouldn't voluntarily do,
that doesn't itself make it a punishment for your non-compliance.
if you are told compensate the people who suffered identifiable loss and donate an additional £1 million to a charity, is that a punishment?
I think you'd actually have to look at how they arrived at that order. I don't think that can be. I don't think it can be dealt with in the abstract, because there is a genuinely difficult question when you have complicated regulatory structures, when you have regulators with multiple powers, and obviously alternative forms of redress like an ombudsman, as to whether you are being punished for your breach. But here we say it was found that that was the right description for what was going on, and that this is actually because of such things as these letters where you're told this is the penalty on the table, but we can agree how we're going to cut that up. This is a reasonably clear example of where it would fall in the punishment box. That if you're going to say, why did you bear this expense? The realistic answer is going to be, we breached the regulations and we are being punished by the regulator. Whereas had you not had regulatory involvement, the realistic answer would be completely different. You might be doing it for all kinds of reasons, which might very often be deductible reasons. But that once in this situation, on the facts found, which was on the basis of of much more evidence than is before this court, my lord, and from evidence from, I think, Mr. Sinclair, who had worked in the regulator, they did find this whole package was intended to punish the breaches. So I don't think the fact that it is not clear where the line might be drawn in some other cases of regulatory action means that the first tier or the Upper Tribunal got this decision wrong. I mean, there's a real distinction, even if it's sometimes hard to evaluate, between something a regulated business does to improve its compliance, even if it's strongly encouraged to do so by the regulator, and think it is told to do as its punishment for breach. And we have actually, the First-tier Tribunal decided the line these agreements fell on in that sense. What I'm submitting is that, having found that, the Upper Tribunal was correct to say that they couldn't then find that bits of that sum that had been redirected stopped being in the broad nature of penalties within the rule in Von Glen and McKnight, and turned back into ordinary compensation.
So the unifying feature, the critical part of your argument appears to be that all these payments were made to avoid the threatened penalty.
Yes, but also, I mean, it is that they were the alternative. You're not given an opportunity to avoid punishment. You are being given an opportunity to take a different form of punishment.
Yep. My Lord's question to you, I think, was, if I may say, as is always the case, very carefully phrased.
Yeah.
It was to avoid a penalty.
It was to avoid a threat of statutory penalty. We say that, absolutely. And it wasn't just not to avoid it in the sense that you're improving your behaviour so that the amount on the table from the regulator will reduce, but only in the sense that you're being told how to divide up the indicative penalty.
The unifying factor behind your submission is this was all done by way of punishment to avoid a penalty.
Yes, as an alternative to a statutory penalty, but it was still a punishment. There are things you could do to avoid a penalty that are not punishment, but that's not this case. And that might include when the regulator starts writing letters to you, hurrying up and making compensatory payments to anybody you think you might have wronged. But that's different to when the regulators concluded their investigation and said, right, we want £18 million, saying, well, this is the way we're going to cut it up. I mean, it might be sensible this one just to take you to the compensation provisions that they agreed. I think you've seen at least some of them, so it shouldn't take long, because that is the distinction between the First-tier and the Upper Tribunal here. So, first, page 12 of tab 1 of the supplementary bundle. Annex 3 deals with both the warm homes discount and the compensation fund. And it's worth bearing in mind here that when they signed this, they don't know it's going to be £554,000. There's a pot of £1 million. And if they so page 12 of tab 1. And I take you to paragraph 3, which is the following page. So this isn't supposed to be a way for them to discharge their existing obligations.
Yes. Actually, this is saying, is this right? This is saying it wouldn't go to discharge liability. Is that the point you're making?
Yes, I mean, in terms of a general view as to what this fund is supposed to be doing, yes, I don't think our case depends on the kind of the technical consequences if one was to litigate over the meaning of that paragraph. but it's clearly not intended to replace existing debts
Or liability.
or liabilities. And then at page 15, you've got the definition of compensation payment. And what I draw from that is the £1 million cap and the fact that if you don't meet £1 million, the rest of it has to be paid to the SPN and GP People Trust.
So, page 15.
Yes.
I can see you pay £1 million into a fund for compensation payments. What would you say? Where do you say we get if you don't hit the million? Something else happens. Where's that?
12 months from the date of publication of fine. This is paragraph 15 on page 15.
Oh, sorry, I got you. Yep, there was the one. Yep, got it. Thank you.
And then the details are dealt with in Appendix F, starting on page 24. And I won't take you through Appendix F at length. I would say what I say about it is essentially a simplified way of claiming the difference between what your tariff on your previous supplier was and your tariff when you moved to Scottish Power if you fell within the conditions of being missold. So the first tier was right, and we don't dispute this is much closer to an attempt to calculate at least some simplified version of loss. This is much more compensatory in nature than, for example, something like the warm homes discount payment or the provisions in complaints handling, where they had a pot of, I think, 15 million and simply divided it by the number of people who applied. So we don't say that the first tier was wrong to see that this is, in a sense, a compensatory process. What we say is it's still part of the the cutting up of the agreed sanction.
Do you say that the label compensation is in this context a bit of a red herring? Because, I mean, what I suppose I'm saying is, obviously, outside this sort of context, payments by way of compensation to customers are probably deductible, are likely to be deductible. They're deductible because they're wholly and exclusively for the purposes of the trade, rather than because there's some magic headed deduction labelled compensation.
Yes, I do say that, my lady.
So here, the real question is whether the payment is in the nature of a penalty, and the label compensation doesn't, you would say, on the facts of this case, assist the taxpayer.
Yes,
it's not a get out of jail card.
No, there's no magic about compensation that makes it deductible. It's an example of where the reason you would give for making the payment would be for the purpose of your trade, or it would be a loss arising from your trade. And one of the reasons the first tier would say is clearly wrong to draw this distinction is that had there been if this wasn't a substitute or a dividing up of an agreed of a penalty, then many of these payments might have been deductible. example, if you fund payments to charity are sometimes given relief, all kinds of benefits.
Yes, often under a statutory
Yes, that's true. That's a bad example. But a lot of incentives or benefits you might give to long-standing customers might be for the purposes of your trade. So it doesn't. That's not the problem here. The problem here is we say that it falls within the rule against penalties.
I'm simply saying
yeah.
I found it a bit difficult to, and it may come from the Herald case, I'm not sure, but there are senses in the decisions below, or at least the FTT decision, that if you can label it compensation, that somehow gives you protection.
And I think it's also a problem because actually a lot of these payments, even ones which are obviously not satisfying any kind of liability or any kind of loss, are described as compensation because we use compensation in a very wide and narrow senses. So we do say that. I mean, that's essentially why we say the Upper Tribunal was right on this point and the first tier was wrong, which is that once you've decided that there was a penalty on this is a way that you've divided up the penalty that you were going to otherwise get, it just doesn't matter that some of it is used to compensate people. It does matter why you are paying this, and if the reason is regulatory breach and punishment, you fall within the rule. Normal compensation the reason would be it's for the purpose of the trade.
And I think, is this right, you also say that the question of whether you pay under a compulsion of some sort is also not the determining factor.
I think we do say that because there's plenty of forms of legal compulsion that wouldn't be inconsistent with a wholly exclusive person.
Well, if you dispute liability and are ordered by a court to pay compensation, you're not doing voluntarily. You're doing so because the court orders you to do it. And yet I think you accept that a pure compensation order of something arising out of your trade, a liability which you incurred because you were conducting your trade, could be deductible.
Yes. I mean, that's, I think, well established.
Yeah.
So let me just understand this. Do you say that, I think these submissions are directed towards the proposition that the payments that were in fact required to be made were not discharging any underlying liability of Scottish Power to its customers?
I think we'd say even if they did, it wouldn't matter.
That's what I was going to ask. You'd say, so if the payments did discharge a liability under a mis-selling claim, for example, you would still say that's a punishment, would you?
I'd say it's been found here that they were punishments. I'd say you might get cases.
When you say that it's been found, do you mean that FTT is found as a fact and we can't interfere with that finding?
To a great, I think in terms of this characterisation, I think the scope of the rule in Von Glen and McKnight is clearly a question of law. But the characterisation that Ofgem was, or GEMA was imposing these were punishments in 134 was based on assessment of the evidence and on a lot more material than is here, and that so I say that is a finding.
But is that's a finding as to GEMA's intention?
Yes.
I mean, it's only the finding of fact. It's a finding of fact. Because the only basis for you drawing our attention to it is to say that we can't interfere with it, which you can only do, in fact, if it's a finding of fact, at best. So you say it's a finding of fact as to GEMA's state of mind. It says 134.
Yeah. No, that's
GEMA intended.
Yeah.
The payments to be punishments. So you say that is the determinative for tax purposes in any case, that it's what the regulator intends, the state of mind of the regulator.
Well, I'd say if this is sort of a point Lady Justice Falk raised earlier on the character and nature issue in McKnight, I would say that the intention of the regulator or the body authorised to punish is at least very highly material to whether or not the character and nature of the payment is that it's a punishment.
So why is that? I mean, what? I mean,
I think it might also, it might, I don't know if I would go so far as it's determinative, but if you're asking why were these paid, well, they paid because the regulator was punishing you or because you were furthering your business. The regulator's intention would seem to be, I mean, it's not as if the taxpayer doesn't know what the regulator is doing.
So, wait a minute. Does it matter what either the regulator or the taxpayer think? I mean, you can't have it surely that it only matters what one of the two parties to this event think. Or do you? Do you say it only matters what the regulators think?
Well, I think it would be difficult to conclude that this was a punishment if the person being punished didn't know that they were being punished, what the regulator was doing. I mean, Look at them.
Sorry, I'm really sort of putting to you that, as I understand it, you've just told us that it's actually very important what the regulator subjectively intended or thought, because you drew our attention to the finding at 134, which you say is very important. I'm putting to you that, is it a bit odd that, if that's right, that we shouldn't take into account also what the taxpayer thinks? Or should we be just, are neither actually relevant to the legal characterisation or the legal question that you say follows from the decision in McKnight? So it's entirely open, it's not a loaded question. I'm just trying to understand what your proposition is.
The question as to whether or not this is a punishment, I mean, starting from the assumption that that is the question in McKnight, that question has to be informed by whether or not the person authorised to punish you thinks that they're punishing you. Because if they don't think that they're punishing you, it probably isn't a punishment.
Does it follow also that it's relevant what the person being punished thinks?
I think
it's 3 minutes to 1. I'm perfectly happy if you want to. If that's a really quick delivery before lunch, then I'm perfectly happy for you to take a few minutes over lunchtime to think about that one together with Mr. Ewart, and Mr. Ewart's got his homework anyway. If you'd prefer to do that,
given that we'll be coming back after lunch anyway, then
I dare say I don't think Mr. Goldberg. I presume Mr. Goldberg isn't going to try and wrap up in the 2 minutes before lunch.
I'd like 2 minutes to think about that.
Touche. In which case, shall we come back at 2 o'clock?